Okay. Good afternoon, gentlemen.
Good afternoon, Judge.
We're here on Lopez. Good afternoon. We're here on Lopez versus Lopez, 20DR 2103. Please enter your appearances.
Albert Batista, present on behalf of the petitioner, Claudia Lopez.
Scott Rowland on behalf of the respondent, Evelina Ramirez.
Okay. I understand we're here today on husband's motion to compel discovery, which was filed on May 4th.
Yes, Your Honor.
Okay. Mr. Rowland, please proceed.
Your Honor, the request for production, it's husband's first request for production that we're seeking to compel the response to, was served on March 9th. So the response was due on or about April 8th. Mr. Batista got involved in the case sometime in that time frame. An extension was granted to Mr. Batista through April 26th. And then we ended up filing a motion to compel, as you said, on May 4th. Your Honor, we would just like an order to compel. We understand that Mr. Batista needs more time. Indicated that to Your Honor in the hearing the other day. What I didn't want to have happen in this situation is that we didn't have a deadline and an order to compel. I think just procedurally that would be the proper thing to happen. I'm okay if Mr. Batista needs 10 days or whatever it is, but I would like an order to compel. So if we do need to come back, then it's more of a contempt situation and not having to come back and ask for a compel again.
Okay, Mr. Batista.
I don't know if you received a response that I sent to your office. Unfortunately, it was about 20 minutes ago. Are you looking at it or not, Your Honor?
Oh, you sent it to my office?
Yes, well, you filed it, but then I sent a courtesy copy to your office, Your Honor.
Oh, I don't have it.
Okay, well, the reason, what I'm requesting is I had intended to get this done before the hearing today. And at 6:30 in the morning, Mr. Rowland sent me an email that said, Mr. Batista, as you mentioned that your client has provided you records and you are working on a response, I would propose that we submit an agreed order which provides some time for you to sort through the documents and file a response. Let me know if you would like to proceed in that way and how much time you would need. We would then submit the order and cancel the hearing for today. To my understanding, that was an offer to an extended time, and I told them that I would just get it done next week, or honestly, I can get it done by Monday. But I mean, at 6 o'clock in the morning.
How much time do you need, Mr. Batista?
I can get it done by Monday, but I was going to get it done today. But you know, I get this email at 6:30 in the morning, and I thought, well, you know, now I don't have to, you know, push through to finish it by noon. So then, I mean, that's, you know, something that I kind of think a little bit misleading to me, because I thought he was agreeing to an extension of time. That's what
I don't know. This is okay. So we're turning something into a fight that doesn't need to be. So let me.
I agree.
It
doesn't need to be.
Well, he filed a motion, Mr. Batista. He doesn't have to talk to you.
Yeah, but he did. That's the point. He solicited me at 6:30 in the morning.
Okay.
No, he contacted me at 6:30 in the morning. I was moving forward to do what I was going to do, and then he contacted me at 6:30 in the morning. So I think that's something that you should consider, because honestly, you know,
the more argument you're making, the less it's being helpful. So here's what we're going to do. I understand Mr. Rowland's offer. You need till Monday, Mr. Batista?
That's fine.
Okay, so you'll have the responses by the close of business Tuesday.
No,
I'm
by
not
Monday.
going to grant or deny the motion to compel, because if I end up granting the motion to compel, then statutorily attorney's fees must be awarded. So I'm going to just have a short order, Mr. Rowland, giving Mr. Batista until Tuesday to respond to the RFPs. And if not, you can reset it on the motion to compel.
Thank you, Your Honor.
Okay.
I'll probably get it done today, though, but I mean, I appreciate
That's
having
right.
until Tuesday.
Your Honor,
Okay.
can I suggest a little tweak to what you're ordering?
Yeah.
And that is that we do an order that says he has until Tuesday. If you're not, and I'll do the order that says you're granting or denying the motion to compel, but that he'll have until Tuesday, close of business Tuesday to provide the documents. And if they're not done and we file a notice of noncompliance, then we should be able to get an order to compel at that point.
I would think that that's fine, except for only to the extent that they're not produced at all. I don't want you using that as an excuse. If he's somehow limiting it properly, I don't want to be granting a motion to compel on that basis.
So if no response is filed.
If no response is filed, yes.
Right. Thank you.
Okay. Any questions with regards to the order, Mr. Rowland?
No, Your Honor. Thank you.
Any questions with regards to the order, Mr. Batista?
No, sir, I think it's appropriate. I had actually prepared an agreed order to that effect, which we didn't agree on. But anyway, I appreciate it, Your Honor.
Wonderful. Wonderful. Well, I'm glad everyone's in agreement here.
You have a great day.
Have a great weekend, everyone.
Thank you, Your Honor.
Bye. Okay, Stephanie, I think my next one is at 1:30.
Yes.
Okay, so I'm going to turn the camera off and mute until then.
Okay.
Bye.
Welcome back.
Stephanie. I'm gonna let everybody back.
Okay.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Mr. Franklin. Good afternoon, Mr. Dupay.
Judge.
All right. We're back on Reyes versus Reyes. I hope that you all had a productive conversation yesterday after the hearing. And we're here today on former wife's supplemental fee motion, which covers the time period September 20th, 2020 through the present. Mr. Franklin, this is your motion. Please proceed.
Judge, I want to, we have a history which is not just indigenous to this case, but in general, my experience, you try to have something finished in an hour or 2 hours and it always goes over. I am going to be I'm going to do my best to be succinct. So I'm prepared. There are only two witnesses, me as the primary witnesses and maybe 3 questions of Madeline Reyes. I know that opposing counsel has something else at 2:30, so I'd like to be as efficient as possible. My client is literally running out of money. She is not going to be able to continue paying the way she did before. She has to raid in or invade her IRA account and suffer a 10% penalty. And she hasn't received any alimony except for like $300, $391 for all of 2021. So on that note, Judge, if I need to raise my right hand, sometimes as an officer of the court, you don't need to, but if I need to be sworn in, I'm going to start testifying.
Okay, let's do that. Madam Clerk, can you please swear in Mr. Franklin?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed, Mr. Franklin.
So, Judge, I'd ask you to take judicial notice of the same fee contract that carries over and is operative for this fee application, just like all the other prior fee applications. That's my fee contract of June 22nd, 2017. It's actually listed as an exhibit, but you've seen it, you've approved the hourly rates. I see no reason to spend any time on that right now because this is like the 4th or 5th fee application.
Well, let me ask you this, Mr. Dupay, are you making any challenge with respect to the hourly rate?
No, sir.
Okay, well then.
I don't know that judicial notice is appropriate for evidence of a contract, but the contract certainly should come into evidence.
Okay, so you have no problem with the contract being admitted as it has been, I think, in the past?
Correct, and there's clearly for the record, there's no objection that the hourly rates that have been charged, that hourly rates as set forth in the contract and that I saw in the invoices are reasonable for the work being done.
Okay, so that hopefully will help. I will admit the contract as an exhibit. What exhibit number is that, Mr. Franklin?
So it's Exhibit A, looking at the updated notice of filing proposed exhibits that we did on June 2nd. It's under A, contract for legal services dated June 22nd.
So Exhibit A will be admitted.
B, Your Honor, are the redacted billing statements covering from September 21st, 2020 through, as currently, I think the cutoff was May 31st, 2021. Now, let me give a caveat to the court, full disclosure, and to opposing counsel. When I started to prepare for this hearing, I realized that technically this is for enforcement fees only. So that caused me to carve out, segregate, and eliminate two areas of billing activity. Number one, any activity after September 21st, 2020 on the 57105 motions. And number two, because I think that's the right thing to do, so I'm saying it voluntarily. And number two, and I'll give you those figures in a minute. And number two is the alimony modification, because by definition, if it's modification, it's not enforcement, and you have not reserved jurisdiction for an award of attorney's fees, not yet, maybe later, but on modification. So what I think would make the most amount of sense and be the most efficient is Exhibit B are all of my redacted billing statements. We've been through this drill before, except not with Mr. Dupay. I'd ask that those come in as the next exhibit. Then I'll testify and I'll give the carve-outs for those two categories of billing activity.
Any objection, Mr. Dupay, with Exhibit B being admitted into evidence?
No, sir, no objection.
Exhibit B is admitted.
And Judge, on that note, Exhibit C, and this I think is going to be my last exhibit. Exhibit C is the summary through or dated as of May 31st. Again, covering the period of time from September 21st, 2020 through May 31st, 2021. And I'd ask that that come into evidence. And as soon as that comes into evidence, I'm going to reduce that figure by the carve-outs for the 57105 activity and the carve-out for the alimony modification activity.
Any objection with Exhibit C coming into evidence, Mr. Dupay?
No objection.
Exhibit C will be admitted.
So here's the arithmetic for the court and for Mr. Dupay. If everybody's looking at Exhibit C, the summary, I think this is the easiest way to do it.
Give me one moment just to make sure I'm there.
Okay.
What was the date that this exhibit was filed?
It's Exhibit C to the June 2nd filing. It says former wife's updated notice of filing her list of proposed exhibits for today's hearing.
Okay, hold on one second. I think I'm there. The one I see is for all professional services rendered through April 30th.
No, there's a later one than that, May 31st, 2021.
May 31st.
Oh, you have the right one, Judge. You're just referring to the date of the supplemental fee motion. You're on the right one. If you click and go to the actual document, you should have the correct exhibit.
Okay. All right, proceed.
So the 115,140.85 number on Exhibit C, that needs to be.
Hold on one moment. We just had Mr. Dr. Reyes join us. Let me let him in. Good afternoon, Dr. Reyes.
Good afternoon, Your Honor.
We are in the middle of Mr. Franklin's testimony. We're getting some feedback on your computer, so I'm going to put you on mute. Okay. Thank you, Mr. Franklin. Please proceed.
So, as I was saying, the bottom line number on Exhibit C, the updated fee summary dated May 31st, 2021, reflects a figure of 115,140.85. That number needs to be reduced because I'm taking out the $2,500 payment to Madeline's Georgia lawyer, Eric Coleman, because I don't believe that should be part of this fee application at the present time. That reduces the figure down to 1112,640.85, 1112,640.85. And then what I've done to be consistent with what is contemplated for today as far as fees taxable against Dr. Reyes, I'll give you two other numbers. I added them together and subtracted the total of the two carve-outs from the 112,640.85. So here are the two carve-outs. For the 57,105, the figure is $39,009.30, 39009.30. Again, that's 57,105 billing activity. The second carve-out is for alimony modification billing activity. That's 8,185. Add those two figures up. It's 47,194. 47,194. I subtract that from 112,640.85, and I'm left with 65,446. That's 65,446, and that is the amount that my client and I are seeking to have taxed against Dr. Reyes as authorized by the various court orders, particularly Your Honor's order that was entered on March 31st, 2021, at paragraph F as in Frank, that talks about all the enforcement time from September 20th, certainly through March 29th, the date of that order. So I extended that a little bit further, but I took out what didn't appropriately belong for today's purposes. I have the allocation, not just the raw figures for the two carve-outs on the 57,105 and the alimony modification. As you would expect, most of it is my time, and I only have one associate. I can give you those figures just to be complete, and then my direct examination is finished. So for 57,105, for me as the primary timekeeper, again, 57,105, I'm going to handle the alimony modification figures separately. The carve-out hours is 56.9 hours. 56.9 hourly rate, pre-approved by the court, 550, multiply that, that's 31,295. My associate, Nadine Goodman, 12.4 hours, 12.4 times 425 is 5270. My daughter, Jessica Franklin, paralegal, been with me, Your Honor, has approved her 125 hourly rate. She has 15.9 hours for 1987.50, 1987.50. You add that up, 38,552.50, and $456.80 of costs for now that should be eliminated. And that is the total that I mentioned in terms of the raw figure of $39,009.30, 39,00930 to carve out of today's fee application. It's a little bit quicker and easier on the alimony modification carve out. For me, as the primary timekeeper, 12.1 hours. Alimony modification for Franklin, 12.1 times 550 is 6,655, 6,655. For Nadine Goodman, 3.6 hours times 425 is $1,530 for a total of $8,185, $8,185. And that's, again, the total amount, net amount, $65,446, that I think is compensable to the former wife, taxable against the former husband. Nothing further on my direct narrative.
Cross-examination, Mr. Dupay?
Thank you, Your Honor. Mr. Franklin, pardon me. Many notes, too little space. Okay. I want to turn your attention to what is in your Exhibit E, tab 6.
Just give me a minute.
Sure thing.
You said Exhibit B or?
E is in elephant.
Okay.
Can you tell me what the title is? Because
Yes, sir.
I want
It
to
is-
make sure we're on the same page, literally.
It is the order granting former wife's motion to enter a supplemental income withholding order, making all future payments to the former wife by electronic transfer, etc.
Okay, it's in front of me. Thank you.
What's the date of that order?
The date of the order is filed on 10/15 of 2020. I have to learn to start writing down docket numbers for everyone's.
My issue is that I don't see things on docket order or docket number. I just see it by date.
Oh, okay.
Okay.
Now, Mr. Franklin, this particular order in paragraph 4 on the second page reserved jurisdiction over the wife's fee claim. Is that correct?
Yes?
Do you know how much of the hours you're seeking here today are inclusive of work done with this particular order?
Okay, I'm going to make this easy for you. The answer to that is no. And just to speed things along, if you ask me for each order, because there are so many multiple orders that are covered by today's fee application, I wouldn't be able to answer that for you.
Okay. Do you know, well, let me first point out, as in the preamble of this order, the motion filed that led to this order was first filed February 14th of 2020. I think in the record it's filed on February 13th. And then it was amended and filed on September 3rd of 2020. So the work you did for your office did with the relation to filing those motions would have been already recovered by you in the last fee award of the November 2nd judgment, correct?
No, let me say it again so it's clear as day. The fee application, if you look at Exhibit B in evidence, you will not see any billing statements, billing entries that predate September 21st, 2020.
Correct. And since the work done on the drafting of these motions is prior to September 21st of 2020, that means you've already recovered the fees done for the work to draft these motions, correct?
Okay, I'm going to give you the same answer that I gave you before. Number one, there is only net time, because I've already carved out two major categories as we went over, time after September 21st, 2020. So I did not, in preparing for this hearing, go through, let's say, 10 orders and be prepared for your cross-examination to say, maybe for this one, there's 0 time. Or maybe there's an hour. I don't know. That's the honest answer. But I do know that if you go through all of the billing activity that is part of this billing, fee application, the way you ask the question, it's not there because...
Let me try. So to the extent you did work on this motion that led up to the order that was prior to September 20th, it would have been included in the prior fee applications. And to the extent that you did work on this particular one after that motion, be it prepare for hearing or whatever, it would have been subsumed in the billing statements that are at issue today, correct?
That's exactly right.
Okay.
And if not that I want to take the time, but if I go around October 12th, 2020, because I would have prepared this order, I'll see some entry for, if Mr. Dupay wants me to do that or the court, I can kind of cross-check it that way. But any of the time before is not part of this fee application.
Correct. But I think you and I are saying the same thing, but my point is being missed. My point is any time you spent on the case prior to September 20th has already been awarded.
Yeah,
I would say-
we all
yeah.
got that.
Yeah.
So I want to turn the court's attention to the motion that was filed on September 3rd of 2020. May I screen share? I have it on my screen.
Yes, please do.
I hope this is the right one.
The motion for an income deduction order?
Yes, I like this little annotation tool, so forgive me, it just helps me point to what I'm looking at. Sir, is this, to your recollection, is this the former wife's motion for the court to enter an amended supplemental income withholding order filed on September 3rd of 2020 that led to this order on October 15th of 2014? I'm sorry, 2020?
I don't have a distinct independent recollection, but it looks right.
Okay. I want to turn the court's attention, I suppose, to the fact that there is no request for attorney's fees in this motion.
Is that a question?
Sir, did your client request to recover attorney's fees for filing this motion?
Okay, Your Honor, I'm going to object to that as an irrelevant question because the order itself authorizes the fees. And the order was entered back in October of 2020. There was no
So your objection is to relevance?
relevance, right?
Sustained.
To date, sir, has there been a ruling from the court granting entitlement to the fees that were incurred for the order that I just referred you back to? The order of 10/15/2020?
Okay, so I think this is going to be helpful the way I'm going to answer it, and it's going to be responsive.
Okay.
When I went back over to prepare for today, Mr. Dupay, there are orders that just simply, in a generalized way, reserve jurisdiction without designating whether there's a determination or an adjudication of entitlement. And then there are other orders that actually expressly state an adjudication of entitlement. When any judge asks me to prepare an order, I don't editorialize or get presumptuous. You and I are working on an order right now. The language that you wanted, I've agreed to. From yesterday, it's going to say expressly the way you want, that there's no predetermination as to entitlement or any amount. And so for every one of these orders, there's either one of two categories. Either it's just a generalized reservation on fees, the way Judge Cohn would have said it, or if he said, I'm granting entitlement, you'll see that language in the orders as well.
Correct. And on this particular order, the language of the order states that the court is reserving on, doesn't use the word reserving on entitlement. Presumably that means it's reserving on entitlement. My question simply is, has there been any further orders with regard to the fees on this motion that grant entitlement prior to today?
The answer is yes, the way I understood the order from March 31st.
Okay. So let's turn to that. That's in tab E13 of your exhibit book.
I have it somewhere else. Hold on, let me check and see if it's there. I think that's it. But if you go to paragraph F.
Yes, sir. On page 5 of 5.
Okay, just 1 second. Yeah. So paragraph F of that order of March 31st, holding your client in contempt, you can read it for yourself, but that subsumes all of the enforcement activity from September 21st, 2020, because that was the date not covered by the November 2nd fee final judgment, certainly through March 31st, 2021.
The way I read that first sentence includes language that says leading up to and including the entry of the 3 October 7, 2020 orders and the November 3rd, 2020 order. How do you read that to mean up through March 31st?
Well, I'm not going to argue with you. It's up to the judge. But the way I prepared the motion, the way I understood it, the judge, and I think he may have said this as an orally pronounced finding, he was covering fees for Ms. Reyes, starting with what was not captured in the nature of enforcement after we had the hearing that resulted in the November 2nd fee final judgment. And that cutoff date was September 20th of 2020. So the first date that relates to enforcement activity is September 21st, 2020. So that's the way I did it. And I believe that was the appropriate way that the judge contemplated it or authorized it.
Okay. At the last line and a half of that paragraph F references inclusive of the March 29th, 2021 order to show cause hearing and the preparation of this court's order is requested by the court. Do you know how many of the hours you're seeking today are relative to that March 29th, 2021 hearing and the preparation of that court order?
I don't independently off the top of my head, but you could have, just like I can, if called to do it, and I hope I'm not, you could go, because my billing statements are pretty meticulous, you could go to that time frame within Composite Exhibit B, and you could figure it out for yourself. But again, I didn't do that, because that would have taken me an enormous amount of time, frankly, that I would have thought was unnecessary and that my client can't afford, and I wasn't going to do it. And then, you know, you have the right to ask me about it, but I didn't prepare for this hearing in that way.
For how long has your client not been able to afford your fees?
I didn't say that. I said I've been paid, but I made a comment that as far as I know, and she's been an excellent client in all aspects from the moment I met her, she has made an application having to withdraw money from an IRA. Why? Because she hasn't received any money, even though she's been awarded substantial monies caused by your client on fees for over $500,000. And more importantly, monies directly to her for alimony. She has not received anything other than one check from your client's employer for $391.77. So yeah, she's now struggling. She has my office to pay. She had an accountant who you became aware of.
So let's just stop. Let me just stop you. The answer is she's current.
Well, she's not 100% current because I asked her for a payment and I haven't received that yet.
Okay. So other than the last payment?
No, she has paid, consistent with my prior testimony, Your Honor.
Okay.
Still on that paragraph F of page 5 of the March 31st order, it references enforcement work on 3 October 7, 2020 orders. Do you know which 3 orders?
They're all in the exhibit list, and I can tell you
there's 5 that were entered on that day, and that this only references 3. So I just didn't know if there was a distinction between the 5.
I don't know why that is. But you're right. I like when I don't have to argue with you. There are 5 orders that were entered on October 7th. There's an October 14th order that relates to this. There are 4 October 28th orders, 1 November 3rd order, 1 March 15th, 2021 order, and the big one was the contempt order.
If you want me to answer that.
Sure.
There were 5 orders on October 7th, 2 related to the Georgia property. The Georgia property was not subject of the contempt hearing.
Thank you, Judge.
Thanks for your help, Judge.
No problem. I apologize for stepping in. I just don't want us to go down rabbit holes here.
Understood.
Limited time.
I hope we can finish today.
The November 3rd order, which is referenced in that paragraph F, but when I looked at it, it had already granted entitlement with regard to that order. Do you know how much of your time was spent, or the time of your office was spent relative to that motion and obtaining that order?
I just said several times, if you ask me questions like that, I can't answer them independently The answer is ascertainable from looking at the billing statements. I did not do that to prepare for this hearing because that would have taken excessive time that I didn't feel comfortable doing or billing to my client.
Okay. There's an order entered on October 28th, which is tab 9. Which has also granted entitlement in favor of the former wife. So I'd ask you the same question. Are you prepared today to tell the judge how much time was spent by your office relative to that motion? Or that motion?
The same answer I gave you. It's all subsumed in the billing statements, and I carefully went through to carve out what I didn't think was in the nature of enforcement that would not have been appropriate for today's enforcement fee application.
Okay. So I can assume the same answer is going to apply to the tab 7, that order.
Mr. Dupay, we don't know each other that well, but if I said that, you can go to the bank on it. I can't answer that question for any of the 5, 6, 10, 11, 12, 13 orders. I didn't prepare for the hearing that way.
Okay. You referenced that you removed some costs on the 57-105. I apologize, I did not write that number down. I didn't catch it fast enough. But can you look at tab C, your summary, and tell me if it's any of those costs as listed there?
Took out one. Hold on, let me get back there. The one I took out is to Eric Coleman. He's Madeline's Georgia lawyer for $2,500. That's the one that I took out.
But you also, I think when you were going over the hours that you carved out, I think you mentioned a cost with respect to 57-105 of a couple $100. I can't recall. I didn't catch the number.
So you're right. I wasn't looking at the summary when I testified about that, and the cost that I took out on the 57-105 was $456.80.
And do you know what, if anything, or if that captures anything that's listed on Exhibit C?
I'm not sure.
Okay. The 57-105 motion began a hearing on February 4th of 2021, correct?
Sounds right. I don't remember independently, but it sounds right.
So that court reporter bill of $111.25 from that hearing would be related to the 57-105, correct?
If that's the date, yes, you would be right about that cost.
And then the motion to modify had previously been heard by this court on February 18th of 2021. So would that court reporter bill for court reporter 2/18/2021 of $95 be related to the modification?
I would agree with that.
Was Attorney Carlton Pierce and the FedEx sent to him have anything to do with either the modification or 57-105?
No. Well, okay, that's a close call. He's the lawyer representing Jason Castro in the 57-105. So in that respect, you could say it relates to the 57-105 activity, and therefore it should be carved out. On the other hand, I was looking for his fee records, and the fee records, just like I wanted to get your fee records and everybody else's, because I want to see with Carlton Pierce, who, by the way, represented Dr. Reyes previously, was Dr. Reyes paying Carlton Pierce? And if so, from what source? So I don't agree that the activity trying to get fee records, which took some time from Carlton Pierce, like it did the first time around, is completely unrelated to enforcement activity.
Okay. With regard to the process that Dr. Reyes was served with on April 6th, was that the modification summons?
I'm not sure, but for the sake of just trying to move on, I'll accept that that probably was trying to serve him with the alimony modification supplemental petition.
Are there any motions that remain?
Hold on. Was that excluded then? Was that cost excluded from your analysis, Mr. Franklin?
No, it wasn't initially. It's $55.
Okay.
I didn't go through the costs as carefully as we went through the fees. You know, I think he's legitimately brought to my attention, which I'm agreeing with, two other costs, one for 55 and one for 95. Although what I can't say, because I delegated some of this to somebody else, I don't know how the figure of 456.80 was arrived at. So it's possible, I don't want to have a double dip going in the wrong direction. The 456, whoever was doing this, and I had two people looking at it, both of whom are experienced and have done these things many times over for other fee hearings, but it's not worth arguing about in the big scheme of things for today with the amount of money that is in controversy. So I have no problem, conceding if we made a mistake and left two other small items of cost in there.
Okay, those are two FedEx bills.
I think it was one FedEx bill and one process server of $55.25. Process server.
Not FedEx. The two FedExes were to you, Judge Cohn.
Okay.
That I see on here. Oh wait, FedEx to Carlton Pierce. No, that FedEx to Carlton.
Your Honor, his answer that FedEx with Carlton Pierce was likely related to enforcement.
Yeah.
Right. To make it easier so we can move on and not fight about $55 or $95, I'm conceding, Judge, there were two items he brought to my attention. If they weren't taken out as part of the 456 that I volunteered in the very beginning, they should be taken out.
Mr.
Okay, and that's $55 and $95.
Correct.
See.
Mr. Franklin, at present, are there any motions that have been filed by your office on behalf of Ms. Reyes that have not yet been heard by this court?
I don't know the answer to that off the top of my head. Okay. I'm not sure. I know that there are motions, let me say this. I know there are motions that I filed that have not been fully adjudicated, and the best example of that would be the 57105 activity and the other matters from yesterday that we didn't attend to because we ran out of time.
Okay. And if they've not been fully adjudicated, other than the 57105, would the other matters, would work done relative to the other matters be part and parcel to the hours you're seeking to recover here today?
I don't understand your question.
Are any of, I guess I didn't do the backwards math, are any of the hours which you're seeking to recover for your time today, does any of that include work done on motions that have yet to be adjudicated by this court?
I don't think so.
Okay, so you haven't spent any time prior to, prior to May 31st on 2021 on any motions that have yet to be adjudicated by this court, with the exception of the modification and the 57105.
I think that's accurate, which is why I, preemptively carved out the time for those two items.
Okay, well, one of the motions that was not addressed by the court yesterday was the motion to, I just had that notice. The motion regarding the assignment of the Georgia home, correct?
Right.
Is any of the time you're seeking to recover today for you personally related to that motion?
I'm not 100% sure. I'd have to go. It's easy to check. If you tell me the dates, I don't mind checking that because I want to be accurate. If you give me the date of the motion, I can look at the billing statements and see if it's in there. I know that's not much time. I prepared the assignment and he was refusing to execute it. And then I filed the motion. So if it needs to come out, I can take it out, but I don't know that it's been placed in here for tax purposes today.
Okay. May I give you the information now? Are you done your answer?
Yeah.
I'm asking you. Yes, go ahead.
It was filed on December 23rd of 2020. And I'm looking, I don't have page numbers, at a billing page from your Exhibit B that starts on December 17th of 2020 and goes through December 24th of 2020. I see an entry a little bit less than halfway down the page for 1222 for 1 full hour of your time, dictating a motion to compel Dr. Reyes to execute the Georgia listing agreement for sanctions. Do you see that?
Okay, hold on a second, because I'm on December 16th and I see a 0.5. But I'd like to say this in response to your question and the comment that the court made previously. He was obligated, your client, Dr. Reyes, was obligated.
I think my question was, do you see the entry on 1222?
Yeah, but the whole point of your question was whether or not.
Yeah, Mr. Franklin, let's make this easy. What you're stating is that you believe you have a legal obligation to receive or for the attorney's fees related to that. What Mr. Dupay is trying to figure out is just what that category is of attorney's fees. You'll be able to testify on redirect, obviously, about that part of it. So for now, let's just concentrate and focus on what Mr. Dupay is asking, which is he's just trying to figure out what entries relate to that motion.
So I was starting to say first, December 16th, there's my entry for a half hour.
I mean this as respectfully as possible, but we are in an examination. I'm going to ask the questions. I'm going to ask that you answer the questions you're asked. And if you have additional information, you can provide it on redirect or closing argument. I want to turn
answering your question.
Okay, all right.
My question was,
let me be the judge.
There's a time entry on December 22nd of 2020. It's the first time entry that you have on December 22nd of 2020. Could you please turn your attention to that time entry? And then I'll ask you my question.
I'm on December 22nd. Go ahead.
Is that first time entry, which says, and I quote, dictate motion to compel Dr. Reyes to execute the Georgia listing agreement and for sanctions, and is entered for 1 hour of BSF time. Is that your time entry related to a motion that hasn't yet to be heard by the court?
No, because I think it was heard yesterday.
Okay. Is there
Your client was obligated to sign the listing agreement twice before, and Judge Cohn made him responsible to do it by Wednesday of next week. What I was trying to tell you to be.
There's no question pending.
Hold on.
To help you, but I'll keep it.
Okay, Mr. Franklin, we're running out of time.
Okay.
Your Honor, there is not sufficient time to go through a thorough cross-examination because the facts aren't being presented in the way that the law requires them to be presented to grant this order. So I would like at this point to do one of two things, just to give the court a heads up. I'm either going to move that we continue this hearings to allow the former wife to put the evidence on in the manner that it needs to be provided, which is to specifically tie the time to each awarded motion. Or if we conclude, I will conclude the cross-examination. I will assume that Mr. Franklin, other than a few more minutes of his redirect, won't have much more testimony to add, and I'll ask the court to dismiss and deny all recovery fees for failure to prove that the work done is related to the motions and the relief that was granted. So I think the most fair way to handle this is simply to continue the hearing, to allow the former wife to put on the necessary evidence in a manner that makes the most sense, that we can specifically tie and make sure that we have the fees that were granted by the court on claims that were pled by the former wife. And this is the order granting, and this is the work done to get us to that order. And this is the next order granting, and this is the work done to get to that order, as opposed to this macro analysis of here's all of the work done in this block of time. Most of it's probably related to these motions, but there's going to be some exceptions to that. And inevitably, this court's going to, like I was demonstrating with that IWO order, this court awarded fees that were not yet granted. And in fact, you can read the motion yourself, Your Honor. They weren't even requested. This court has granted fees for a motion. Now, it's probably not very much. I don't know. I haven't seen the time records, but you granted fees for a motion that wasn't even, where fees weren't even requested, because we're taking this macro position of let's just get this big block of time and we're not doing it the right way, which is, let's analyze, this is the fee award, and backtrack, how did we get to here and what was the work done to get us here? And if we take that shortcut, I understand it's a shortcut. I understand to do it the right way is potentially expensive. I get it. But if we take the shortcut, things are going to get missed, corners are going to get cut, and incorrect amounts are going to be awarded.
If we were doing that, is there any reason that we couldn't make the determination through summary judgment proceeding? If, for example, Mr. Franklin came back and said, motion A, this much time, motion B, this much time, motion C, this much time, and then you came back with motion A, motion B, entitlements granted, I disagree that he's entitled to motion C, do we need to come back for the hearing on this? Or would we be able to just grant on the papers? Grant or deny on the
I would say most likely we could grant, most likely if Mr. Franklin's able to identify what would, especially the orders that have entitlements already been granted, if we can specify what fees were where it's already been granted, we can probably stipulate as to the reasonableness of the amount. I don't know that there's going to be a whole lot of dispute there. It's the fact, and that my concern that there's work done where we haven't gotten that resolution yet. So to answer your question, the answer is we could probably do it without a lot of evidence where we're just arguing over, okay, should entitlement be granted on these additional orders? There might be some factual, I can't promise I won't have some disagreement with, I don't think that should be included in enforcement of this kind of thing, etc.
Yeah, but will most of those disputes be legal disputes rather than
Probably.
factual disputes?
Probably, they wouldn't, yeah, probably. Most likely, I feel that way, yes.
Judge, can I be heard on that for a moment?
You can.
So there's so many orders. There are different ways to do this. There isn't one cookie cutter, one size fits all. There's certainly wrong ways to do it, but there may be multiple right ways or appropriate ways to do it. There are, I think, 11 orders that are consumed by the fee application and as authorized in particular, but not conclusively, by Your Honor's March 31st contempt order. Where you indicated an adjudication of entitlement in favor of my client for all the reasons that are well established in this record. Now, having said that, I chose not the easiest way in the world to prepare for this hearing, but I also chose not to go ridiculously crazy. Lawyers, they sometimes get into trouble for doing too little, and then they get called on the carpet for doing too much. So I went ahead and I did the right thing by volunteering to carve out of the two biggest areas of activity. I don't want to have to go back unless I'm court ordered for a client in this horrible situation. And have to say for this out of 11 or 12 orders, and then have to go back and say, okay, 2 hours here for this one, 3 hours here for that one, 5 hours there. That shouldn't be necessary. There's no case that, and I've been doing this a long time also, there is no case that says I have to do it like that. I would agree with Mr. Dupay, and it would be much easier the way he would want to do it if we were talking about one order. If I had 15 pages of legal activity and all different kinds of reasons for potential carve-outs, then I would agree with him. If we were looking in a vacuum, in isolation, here's the one thing out of 15 that gives you the right to attorney's fees, then doesn't take that much time to figure out what the fees are reasonably related to that one item of work. But here, it's the total opposite. You have so many orders, so many reservations, and I did it in an appropriate way. I didn't just give raw numbers. I gave the raw numbers, the hours, and the hourly rates. Mr. Dupay, I think the real question to ask is, how much more time do you need to cross-examine me? So
here's the thing is that I don't think he needs that much time to cross-examine, but I think he's raised a point that could be fair. What he's basically saying is that within all those orders, there are some of them where fees are explicitly granted. no doubt that occurred. I think it was the March 8th order that related to most of those orders. And then there are some others where it is not that simple. And there's no way to parse it based on how we're doing it right now, as you've admitted. So I think I'm left with a situation whether or not we do this the fast way or we do it the right way. And I'm also left with a situation where there's already a giant attorney's fee deficit that Dr. Reyes owes. So I'm not completely clear on why not doing it the right way in this circumstance wouldn't make more sense, given that how much of it do you already have on a judgment for attorney's fees with respect to him? It's over. Is it nearly $500,000 now?
Yeah, but that defeats the purpose of somebody that continues to defy court orders and make my job more difficult. He hasn't. Your Honor knows where he stands and that he hasn't produced any of the documents. So
I understand, and that was the point of the orders, and entitlement was granted on a lot of them, and you will. I mean, no spoiler, you're going to get attorney's fees on majority of those orders. I mean, it's already in the order, and I don't think anyone's going to be disputing that. Well, I guess one question, Mr. Dupay, as I have, is under your, if I was to continue it, obviously an accounting analysis needs to be done. That costs money, and that's going to be costing money that at least initially will be charged to Ms. Reyes. How do you solve that problem?
I didn't write that law, and I feel like there might have been a change in this law, but there are 8. Well, first I did the math. There's 8 motions where entitlement has been granted, and 5 that it's been reserved. So that's the split. We have 13 total orders, 8 and 5. 8's already been granted. I believe the law says, with regard to the entitlement that's been granted, any hearings to determine the amount, the fees and the time spent to determine the amount is not recoverable. I believe that's still the law.
It's a commercial case, not a family case. You're right if that's a commercial case in most of the districts, but not a family case.
In the second, under the White, I think it's White versus White. I think I always get that name wrong though. I will look into that law because I something in my brain tells me that law recently changed, but I need to verify that in my own head. In any event, I mean, I'm happy to be the first one to do it, to take of the 8 where entitlement's already been granted, to put my analysis together. I don't think Mr. Franklin will like it because there's going to be some entries that are probably deal with multiple issues, maybe a little bit here, a little bit there, or he talked to his client, he redacted the subject matter of that conversation properly, and I don't know if it covered that. I'm happy to take a first stab at those 8 to figure that out. I don't know how else to do it, Judge. The law says it's the former wife's burden of proof. The law says she has to be able to prove that the work done was related to that motion. If we finish here today, I'm going to ask the court to deny the relief in its entirety for failure to prove. And I don't think that's fair, and I don't think that's what Your Honor is going to want to have happen in this case with this much money that we're talking about.
Judge, let me bring one other area of the law to Your Honor's attention, and one of the cases is a case that I handled successfully at the 3rd. There's a body of law, and it works in family just like it works in civil cases. If the work is inextricably interrelated, and you may remember these cases or know them, there's a whole bunch of them, and they arose from civil cases where you have statutory fees, contract fees, and then you may have common law claims, and the common law claims may not carry a fee recovery associated with it. The law is, and it applies here, the more I'm thinking about and listening to opposing counsel's argument, if the work is all inextricably interrelated, then the court always has the discretion to award all or the bulk of the fees. Now, I did the right thing by carving out. If counsel is saying, well, you carved it out and that's appreciated, or I was going to go over that with you anyway and you stole my thunder, but you didn't carve out a few other items, then Judge, I'm willing, I don't want to obviously cause my client more financial harm in trying to collect money for all the aggravation and bad things that her former husband did, for which he's entitled to get compensated. So it's like, I don't want to chase my tail and especially after, Dr. Reyes hasn't paid a penny and we haven't even, one of the things yesterday was the real contempt determination to punish him in some way with a new purge with regard to the alimony. She can't keep living on all these more additional months passing with a whopping total of $391. That's absolutely egregiously unacceptable.
Okay. Mr. Franklin, how long do you think it would be for someone to go through your bill records and connect it with the particular motions, knowing that it's probably not you at $5.50 an hour?
Well, my daughter, who's a talented, really good paralegal, otherwise, even if she is my daughter, she wouldn't be with me. It took just to do the carve out for the 57105 and the alimony modification, it took like almost 2 hours.
Okay.
And, and I get that. I told them to do that, but to have to go through this again and, especially where things are, that you could argue it both ways. I understand Mr. Dupay says, well, if you're dealing with Carlton Pierce, doesn't that smell like more of the 57105 rather than enforcement? And if it's a close call, then maybe Your Honor needs to be the one to ultimately resolve that. The same thing, he was held to the responsibility of not one, but 2 orders to sign the listing agreement. Your Honor, a 3rd time ordered that yesterday. To me, that's part of the enforcement. Those fees are appropriate. Now, arguably, and this is why it doesn't, to me, make sense to beat this horse for another hour or 2 hours or, doing it by way of paperwork, like in a federal case where some judges say, write down what your objections are and then write down your reply within a certain time frame. On the assignment, that arguably is part of the enforcement. I see that both ways, to be perfectly candid with the court.
And I understand that. I understand your position with respect to that. It seems to me, really, that the best course of action right now would be to get the categories, based on the motion to take Mr. Dupay up on the offer to continue this, to get the categories. If you've already carved out what is really the bulk of the time for those 2 motions and we're left with, I mean, based on where you started, you're only like half.
I have an idea. I just thought of an idea.
Great, love ideas.
Okay, I'm saying this to be fair both ways. And I've tried to do that for the short period of time he's been in this case. If he will, this is a compromise. If he'll tell me, because he obviously did some level of homework here, if he will tell me what areas he's concerned about, he doesn't even have to give me the billing entries, but if he wants to do that, then we could do it like a lot of judges in Dade and Broward and probably around the state. He can object and I can respond, or we can do a little bit of a shortcut and he can tell me just the areas. Like, for example, the assignment of the Georgia property. If he gives me, whatever the categories are, the subject matter, the motions, then I can respond to that.
I can tell you what they'll be right now. There'll be the 5 motions where I didn't grant entitlement. That's what he's going to ask for.
Yes and no. Well, I take it back. There's going to be I would say there's almost 3 categories. There's a category that he's talking about where I don't think you can get it right now anyway because they're not ripe, they haven't been heard, it's not even arguable. Then there's the category of what's related to the ones you've reserved on because you don't know if you're getting them or not until the judge says I'm getting them or not. And then there's going to be the things that are clearly I could go along with the things that have already been granted. We just need to put numbers on them and be done with it.
Okay. So since we're running out of time today, and if I do continue this hearing, just so your clients don't have to be present, do you want to really quickly do your examination of Ms. Reyes, Mr. Franklin?
I have a 2:30 with Judge Schreiber.
Judge, can I ask 3 questions? Because that's all I was going to ask her.
Yeah, real quick, because I cannot imagine you're going to have any cross-examination on this, Mr. Dupay.
No problem.
Madeline Reyes, please raise your right hand. Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. Ms. Franklin?
Ms. Reyes, you heard me more than once, as your lawyer, articulate to the court and to opposing counsel how much money you have received based upon the current
We'll
income.
stipulate it was
withholding.
accurate.
Okay. I still would like her to answer, Judge, for the record. One question.
One. Hurry.
Okay. Madeline, how much money have you received in all of 2021 for alimony?
$391.77.
And tell the court briefly in your own words, where you stand now in terms of having to continue to fund the cost of this litigation, my office for the work I'm doing, the lawyer in Georgia, and any ancillary costs like the CPA that testified yesterday. How is that going to get paid if you still don't get any alimony the way you haven't been getting, and you're not getting any reimbursement on the fees that have already been court awarded to you?
I've had to withdraw money from my IRA, and I'm incurring a 10% penalty just to get my bills paid. That's the only way I can do it. I don't have any other money.
Okay, thank you very much. We do have to cut this off. So how long will it take for you to get the thing done with the bill records, Ms. Franklin?
Well, I'm not sure what you want me to do.
Categorize it by motion.
By motion?
Yeah. Or by order. You know what, Mr.
Let me
I'm
have
sorry,
until Wednesday of next week, please.
You have more time than that than you want, because it's on you. So we'll just say 2 weeks from now. Is that fair?
So what I need to file is some sort of document that allocates.
And it could
from
be a
the billing
summary.
records, a fee.
Yeah. It could be a summary because your exhibit's already in. All right, Mr.
All right,
DePace,
thank you, Your Honor.
we need to, I don't want to upset Judge Stryber.
Thanks, Judge.
Thank you, Your Honor.
Okay.
Have a good
Bye,
weekend.
everyone.
Welcome back.
Hey, Stephanie. All right. Okay, we're bringing in some people now. Good afternoon, Miss Human.
How are you, Judge Cohen?
Doing good. Doing good. Hold on a second. Let me bring in Mr. Batista. Good afternoon, Mr. Batista.
Good afternoon, Your Honor. How are you?
Doing good. Doing good. A little wet. Doing good. I know we're a little bit early. Do either of you expect to have either of your clients here?
No,
No.
All right. Any reason we can't proceed a little early?
not at all.
All right. I understand, Mr. Batista, you are filing a motion to withdraw,
Yes, Your Honor.
and it's unopposed.
That's correct. I believe
Okay.
Ms. Human has no opposition to it.
No.
Okay. Then that will be granted. You already filed a proposed order on that, right?
Yes, sir. Yes, Your
And
Honor.
it includes the client's address and everything.
Yes, it does.
You're also voluntarily withdrawing the motion for rehearing.
Yes, and Ms. Human had withdrawn her motion for attorney's fees, so we came to an agreement.
Okay. Has that order been submitted to me yet? It may have been. I just haven't seen it yet.
The voluntary dismissal, the notice was filed. I didn't send in an order. I can send the order.
Okay.
I will too. Or would you like to just both of us send an agreed order so that it covers
That
it?
would be the best.
Okay, we'll do that.
Okay. That was easy. Is there anything else with this one?
The only reason I showed up, Mr. Batista, is I'm hoping that you could do me one quick favor. I don't know if you're willing to do this or not. Now that I don't know if you're going to have any further contact with Mr. Imicus. His share of the quadro was $250. If we could have just wrapped this up and just get that over, that would be awesome. I don't want to file a motion for $250.
I'll be honest with you. I don't think he has any money. He's unemployed. I don't think he has a phone. I don't think he's even living in his, I don't know where I think he's living with his girlfriend now. So, I'll reach out to him, but I would suggest to you, if there's a deadline, that your client should pay the money to get the quadro, and then if you want to try to recover it from Mr. Imicus, that would be the best suggestion, because otherwise you shouldn't be waiting on that money in order to get the quadro, because I believe there was a deadline for that. Is that correct?
That's right. And she did go ahead and pay it. So all I'm asking, if you just be willing to relay that information to him, and what happens to it, I understand that's not your concern.
No, I'll let him know. I'll put that in. I'm going to send him a letter along with the orders, and I'll obviously, include the fact that he does have to pay that $250.
I appreciate it.
But my understanding from the last time I spoke to him was he's going in a direction of not having less than he had before.
Understood. All right. Thank you. I appreciate your help, though, at least reaching out.
Well, I appreciate it, Ms. Human. It's always a pleasure speaking to you, and also, Your Honor, appreciate your time.
Thank you. Glad I could
I'll send
do
you a
not much
agreed
here.
order.
All right.
You're
Thank
a
you
great
both.
judge. Thank you.
Have a good weekend. Bye.
Thank you.
Good afternoon, Mr. Koenig.
Good afternoon, Your Honor.
Okay. We're here today for a uncontested dissolution of marriage in the case of Seabury versus Seabury, 21 DR 0845. Please enter your appearance.
James Kernick on behalf of the wife, Melissa Seabury.
Okay, and though there does appear to be a new last name, is that you, Miss Seabury?
Yes, this is, my name is Melissa Turvey Seabury.
Okay, got it. All right, Ms. Kernick, is there any reason we shouldn't proceed to final dissolution today?
No, Your Honor.
All right, and do we expect the husband to be here?
There's a notice and waiver of appearance signed, and we don't expect him to log in.
Okay, and I can say that there's no one fitting his appearance in the Zoom room. Although I do have a Jesus in the Zoom room, which is weird.
Here to bless the divorce.
Yeah. All right. In that case, Madam Clerk, can you please swear in Ms. Seabury?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do, yes.
Can you please state your name and date of birth for the record?
Melissa Turvey Seabury, January 25th, 1980.
Please proceed, Mr. Kernick.
Thank you, Your Honor. Ms. Seabury, you and your husband were married on April 21st of 2018 here in Naples, Florida. Is that right?
Yes, that's correct.
And your husband is Donald Seabury?
Yes, he is.
And the two of you have lived in Florida for 6 months before filing for this dissolution of marriage?
Yes, we have.
And do you believe that your marriage is irretrievably broken at this point?
Yes.
And do you believe that any marriage counseling could help save your marriage?
No, I do not.
Now, you and Donnie, your husband, you two have a son that was born on August 24th of 2017?
Yes, we do.
And that's Shane?
Shane Seabury. Mm-hmm.
Okay, and you two have no other children born of the marriage. You're not currently pregnant, correct?
No.
Okay. And you signed a marital settlement agreement and parenting plan on April 2nd of 2021. Is that right?
Yeah. Yes, we did.
And looking at that settlement agreement and parenting plan, do you recognize Donnie's signature there below yours?
Yes, I do.
And does the marital settlement agreement and parenting plan resolve all of the issues regarding this matter in your marriage?
Yes.
Did anyone pressure or force you or coerce you in any way to sign marital settlement agreement or parenting plan?
No, they did not.
Do you believe the marital settlement agreement is fair?
Yes, I do.
And do you believe that the parenting plan is fair and also in the best interest of Shane?
I do, yes.
And finally, would you ask the court to enter a final judgment dissolving your marriage today?
Yes, I would.
Your Honor, I have no further questions myself.
Mr. Kernick, is Ms. Seabury seeking a name change or return to her maiden name as a result of this?
I don't believe so. Having the son, Shane, Ms. Turvey, you don't request to have your last name changed, do you?
No, I'm going to keep, if I can, the Melissa Turvey Seabury, both because of my son, so.
Okay. All right. Thank you. The court has reviewed the file and also sees that the husband has filed a waiver of his appearance today on May 10th, 2021. The court finds that it has jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing this petition, and that the marriage is irretrievably broken with one minor child. The court will therefore dissolve the marriage and restore the parties back to single status. The court also finds that the parties have entered into a marital settlement agreement and a parenting plan, and that they have done so freely and voluntarily. The court notes that the parenting plan is in the best interest of Shane, as it does allow for very time sharing between both of the parents in a very fair and equitable manner. For all those reasons, the court will grant the dissolution, but retain jurisdiction to enforce the terms of both the marital settlement agreement and the parenting plan. Mr. Kernick, have you prepared the final order in this case?
Yes, Your Honor, I sent via Word format to Cheyenne. I want to find the date. It was before she
I
went
probably already have it. I haven't looked yet. But
Tuesday.
I will review the final judgment and then I would enter into it. Best wishes to you, Ms. Seabury, in the future, and best wishes to Shane as your and your ex-husband's relationship enters into a new phase.
Thank you.
Thank you,
Thank
Mr.
you, Your Honor.
Koenig. Have a great day.
You too, Your Honor. Thank you.
Bye. Beckman and Ward. Beckman and Ward. Good afternoon, Miss Angelito.
Good afternoon, Your Honor.
Is your client with you?
Yes, Your Honor.
Oh, okay, great. So I was searching the Zoom room and didn't see anyone meeting his description.
No,
Okay.
here. Yes.
We are here for a final dissolution in the case of Beckman versus Ward. This is case 220 DR 2255. Please enter your appearance, Miss Angelito.
Nicole Angelito on behalf of the husband, Jake Beckman.
I looked down for a second and then I looked up, you had changed dramatically. Okay, Miss Angelito, is there any reason we shouldn't proceed to a final judgment today?
Not that I am aware of, Your Honor.
I see that Faye Ann Ward has waived her appearance here today, but do you have any reason to expect that she will be here?
No, Your Honor.
Okay, all right. Then, Mr. Beckman, we're gonna have the clerk swear you in, and then we'll proceed.
Yes, sir.
Madam Clerk, can you please swear in Mr. Beckman?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you please state your name and date of birth for the record?
Jake Edwin Beckman, date of birth 11/30/1982.
Okay. Please proceed, Miss Angelito.
Okay. Mr. Beckman, who are you currently married to?
Faye Ann Ward.
And have you and Miss Ward been residents of the state of Florida 6 months prior to filing this action?
Yes.
When were you married?
November 9th, 2019.
And is your marriage irretrievably broken?
Yes.
Were there any minor children born of your marriage?
No.
To your knowledge, is Miss Ward currently pregnant?
No.
Have either you or Miss Ward been a member of the armed forces within the last 30 days?
No.
Are you and Miss Ward both over the age of 18?
Yes.
Are you both mentally competent?
Yes.
Did you both voluntarily enter into a marital settlement agreement on March 24th?
Yes, we did.
And are you fully satisfied with the terms and conditions of that settlement agreement?
Yes, I am.
Are you asking the court to adopt that settlement agreement as part of its final judgment?
Yes, please.
Your Honor, I have nothing further, and I do not have a name change request from Ms. Ward's counsel prior to this hearing, so that's why it does not appear in the judgment.
She doesn't even have the same last name, so it would be weird.
Yeah, that's what I figured.
Okay. The court has reviewed the file in the marital settlement agreement. Also notes that Ms. Ward has filed an answer and waiver of her appearance here today on April 26th. The court finds that it has jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing this petition, and that the marriage is irretrievably broken without any minor children. The court will therefore dissolve the marriage and restore the parties back to single status. The court also finds the parties have freely and voluntarily entered into a marital settlement agreement that resolves any disputes as it relates to marital assets and liabilities. The court will reserve jurisdiction to enforce the terms of that marital settlement agreement. Ms. Angelito, have you sent me the final judgment?
Yes, I sent it to Ms. Phillips on Wednesday because she said she was going to be out today.
Perfect. Then I will look for it, and when I get it, I will review it and sign it. Best wishes to you, Mr. Beckman, and also to Ms. Ward in the future.
Thank you, sir. Appreciate it.
Thank
No
you.
problem. Have a good weekend.
You
You
too.
too.
Bye. Okay, I think we're down to the last one. Esmeralda. Okay, Jesus. Gilhart.
Oh, Mr. Godin.
Good afternoon, Mr. Gilhart.
Good afternoon, Your Honor. How are you?
Doing good.
That's good. It looks like my
Jesus is connecting the audio right now.
Yeah.
Oh, I got it.
Good afternoon, Ms. Garcia. Good afternoon, Ms. Garcia. Can you hear us?
Ms. Garza, yes, I can.
Garza, apologize for that. And
No
good
worries.
afternoon, Mr. Godinez. Can you hear us?
He's muted.
You are on mute.
Okay.
Okay, excellent. Mr. Gilhart, we are here today on your motion to withdraw, correct?
Yes, Your Honor.
Okay. Is there any opposition to this
No,
motion?
Ms. Garza's represented as well by Attorney Cliff. He emailed me and said that there's no objection, that he didn't have to attend.
Okay. Mr. Godinez, can you hear us?
I can hear you.
Okay. Your attorney's filed a motion to withdraw representation. Do you have any opposition?
My thing is that why did I have to show up today or not? I mean, this is the fastest. As soon as I told him I wasn't paying him no more because they took all the money and didn't do crap, now he all of a sudden gets a court date real quick. I mean, it's just a waste of time. I had to take half a day off for this nonsense. I had actually told them I didn't want to pursue it or I was done with them because they haven't done nothing since I hired them.
So it sounds based on that there's no opposition to Mr. Gilhart withdrawing as the attorney for you in this matter. For those reasons, the court will grant the motion to withdraw. And Mr. Gilhart, have you prepared an order?
Yeah, I think my paralegal emailed it this morning.
Okay. Wonderful. Anything else?
That's all, Your Honor.
Okay. Best wishes to everyone going forward. I hope you have a good weekend.
Thank you.
Your Honor.
Bye.